This was filed 2 days ago now. It's the response to Judge Indira Alwani's most recent amended TRO that we just looked at. The White House, the government, the elected branches of government's opposition to Planned Parenthood's motion for a preliminary injunction. So now we're looking at the TRO being converted to a durable preliminary injunction that in theory would be in effect for years of litigation, which of course the White House is not going to allow. And I'm just going to touch on how ridiculous. Mostly, I'm going to focus on the constitutional arguments made by Planned Parenthood. They are so specious and so BS that properly the lawyers for Planned Parenthood should be subject to Rule 11 sanctions for making dishonest legal arguments, patently dishonest legal arguments to the court. Of course, they know full well that this court, this judge, Indira Alwani, will never issue sanctions against lawyers for Planned Parenthood. But she should. A fair judge would. So this is the White House now responding to the most recent TRO, telling them they have to keep paying for elective abortions through Planned Parenthood. Both houses of Congress passed a bill, the one big, beautiful bill. I love how they do that. That's just to get under her skin. And the president, your president too, Judge Indira Alwani, the president signed that bill into law, among other decisions about how to allocate limited federal funds was a provision that restricts the type of entities that may receive federal Medicaid funds. In particular, that provision directs that certain tax-exempt organizations and their affiliates may not receive federal Medicaid funds for a one-year period if they continue to provide elective abortions. So, is Planned Parenthood named here? No. Are there other organizations other than Planned Parenthood that fall within the scope of this definition? Sure. That makes this not a bill of attainder. Excuse me, folks. I got to blow my nose for a second. All right, I'm back. Ooh, that made me dizzy. In other words, the bill stops federal subsidies for big abortion. Big abortion. All three democratically elected components of the federal government, the House of Representatives, the U.S. Senate, and the presidency, collaborated to enact that provision consistent with their electoral mandates, how the American people wanted their hard-earned tax dollars spent. But Planned Parenthood now wants this unelected, black-robed, tyrannical, inferior district trial court to reject that judgment and supplant duly enacted legislation with their own policy preferences, including the policy preferences of Judge Indira Alwani, super legislature, overlord of the United States. Indeed, they demand emergency injunctive relief, forcing the government to continue to support them with taxpayer funds. That request is legally groundless and must be firmly rejected. Planned Parenthood's chief claim seeks to facially invalidate the defund provision. Those constitutional claims are utterly meritless. Those are the ones we're going to focus on here. They assert the provision is a bill of attainder, even though it neither targets nor punishes Planned Parenthood. It merely declines to fund entities not limited to Planned Parenthood that perform elective abortions. They also claim the provision retaliates against them for advocating for abortion. But this law turns on action, not advocacy. So it's not a First Amendment violation. And they invoke equal protection. In other words, that they're being treated differently than similarly situated abortion providers. But they offer no viable theory of discrimination. At bottom, Planned Parenthood relies on invented abortion-only jurisprudence that the Supreme Court has discarded. And they're talking here, of course, about the Dobbs decision that reversed Roe v. Wade. So while Roe v. Wade was in effect, the federal courts would all look at Roe v. Wade and say, abortion's a constitutional right, according to Roe v. Wade. So we're going to give it 1,000% respect, in any attempt to constrain a constitutional right like abortion has to be rejected. But Dobbs overturned Roe v. Wade. So there is no longer a controlling body of abortion-only law that gives abortion some special privilege, protection from legislative constraint. Of course, Indira Elwani has grown up her whole life as a feminist progressive for whom abortion and Roe v. Wade was the penultimate expression of political power for the Progressive Feminist Party that ever existed. Pivoting from those sweeping theories of constitutional law, Planned Parenthood also suggests a small number of its members would not independently qualify as prohibited entities under the bill, that there are affiliates that should not be covered by this restriction because those affiliates do not themselves provide abortions. And they're concerned that those affiliates that should not be included in the ban, the Medicare ban, will nevertheless be swept into the prohibition. They argue that the defund provision does not cover these affiliates, and if it does, it should be unconstitutional. But of course, those need to be separated for separately. And by the way, those affiliates, they're not even plaintiffs in this action for the TRO. They're not parties to this dispute. So Planned Parenthood, in the second, not the constitutional claims, but the second set of claims about, harm to the affiliates, Planned Parenthood is suing on behalf of other people. You can't do that. There's no class here. They're not similarly situated. If the affiliates want to sue because they believe they have a cause of action, they're being harmed, they need to show up in court and be plaintiffs. And these affiliate claims are the only claims that this court's amended TRO found there was a likelihood of success on the merits, a condition for issuing a TRO. Planned Parenthood presses those contingent claims only as to a small subset of members, these affiliates. But the court granted a TRO for all of Planned Parenthood. Even if these claims did have a likelihood of success, they could not justify the expansive relief this court granted because they could never protect Planned Parenthood itself, only the affiliates, and likely not even them. All these claims fail on multiple grounds. For one thing, any dispute over whether the provision applies to the affiliates is premature. The government has yet to construe or apply the provision or define who's covered. Whether any particular entity is prohibited under the statute cannot even be determined until October 1st, when the statute goes into effect. So Planned Parenthood could not seek a declaration that the provision applies or does not apply to particular people, let alone that a preliminary injunction is appropriate. There is no ripe Article 3 controversy. No one's being harmed yet. No identifiable party, and no party in this suit. Planned Parenthood has no cause of action to seek preemptive relief based on a potential dispute over statutory construction or the application of the statute to particular facts. That also means there is no occasion to reach the contingent constitutional claims that Planned Parenthood is asserting on behalf of other people, the affiliates. So procedurally, all of this is defective, but it's also defective on the legal merits. Seeking to elevate standard statutory language about corporate form into a constitutional concern, whether someone's Planned Parenthood, Inc. or an affiliate of Planned Parenthood, Inc. Beyond the futility of these claims on the merits, Planned Parenthood fails to demonstrate imminent irreparable harm to justify an injunction, asserting only classically reparable harm. In other words, what they're claiming is we won't be getting our money. Money is reparable. You can always be paid the money later. And irrelevant potential harm to patients. Patients are not going to get timely medical care. patients are not part of this lawsuit. They're not plaintiffs here. And Planned Parenthood, a company, cannot be a class representative for individuals. And the balance of equities and the public interest firmly favor the government's interest in enforcing a statute duly enacted by Congress and signed by the president, especially because these third-party patients can always seek Medicaid-eligible services from other providers. They don't have to go to Planned Parenthood.
Thanks for watching this highlight segment of our full-length Law of Self-Defense live stream. If you enjoyed this content, make sure to give us a like and subscribe for more expert analysis on politics, law, and how to be hard to convict. And to watch the full-length episode of this show, just click right here. Stay safe.